fifth. There's another matter on fifth, no? On fifth. It's a matter on five. Didn't I fifth is on five? The other matter that he mentioned leave this matter along with on fifth. Anyway, because he gave him right on the basis of promissory. When a promissory estoppel right is being made, burden is on the state to prove there is no promise. Means that's the judgment of mistake. So that's up petition. Don't no worry. Good for petition. Don't you please? No, but it's good for the petition. Don't file it. And don't file it. Good for them. If it takes 4 years to file an affidavit, 4 years. 4 years is too early, na? For the state. And what about the center? Center's thing is this. No one from the center. Include us appearing on behalf of the state respondent, more particularly the Industries Department of the Government of Assam, submits that a final opportunity may be granted for filing the affidavit in petition. So, taking into account Mr. R.S. Mitra appearing on behalf of the petitioner submits that the writ petition has been pending for the last 4 years, and as such, the delay on the part of the respondents to file the affidavit have duly affected the petitioner's industry. Considering the above, list this matter again on 27th of March 2026. Affidavit be filed by the state respondents on or before 23rd of March 2026. It is observed that if no affidavit is filed by the respondents, including the central respondents appearing on behalf of the central government, the instant writ petition will be taken up for disposal on the basis of the materials already. State of Assam, who appears for the state? What is this case? State of Assam filing a writ petition. What is it? here. Now, first of all, how is the litigation maintainable? Should I dismiss on non-maintainability? No, what do you mean maybe? It's an order passed by the civil court. How is the litigation maintainable? You could have moved under 227, it's a different aspect. 227 also, the jurisdiction is very circumscribed. There, nothing remains. And who has filed the other one, non-legal charge? Who are you? That's the no, no. During election time, stacking the account is vague. Then the returning officer, nothing can be done. 12 o'clock, provide the head of account. This is a continuous violation of an order passed by the order passed by this court is on 6/2026. Directing you to release. You are not released. So therefore we put it up that you are not attached that amount, and then one what account is there. No correct. Hello? Whether a person is suffering, if he has got that amount of 6 was into, he has got the failure, failure. He's going to see, release this much, much, and the 19 totally the ground that you could not have filed it, then an order passed by force in the case, decided to be. How can you exercise people? Law is no, whatever may be. Why on earth are you moved it? This is a case of form thing. Form of thing. Then also they are not looking to the area. That is no, the amount has already been deposited before the instant distribution has been filed as Mr. Consider referring now. Challenging an order to challenging various orders dated 5/11/2022, all dated 5/11/2022 in money execution case number 11 of the 2019, money execution number 12 of the 2019, money execution case number 13 of the 2019, and money execution case number 15 of the 2019, and the order dated 16/11/2022, past June, money execution case number 32 of the 2019, money execution case number 33 of the 2019, and money execution number 34 of the 2019. It has been submitted as a bar by the counsel appearing on behalf of the parties that the amount in question for which execution proceedings have been initiated have already been deposited before the learned court. Under such circumstances, then that point of time it was deposited. That amount for which the execution activity already deposited. However, so deposited for the learned execution court, the actual entity of claim, if you either as it may, it is that these orders are being passed by the learned execution court in size of their citizens by the learned court of the learned petitioner, learned court of the petitioner just under the kingdom in exercise of civil jurisdiction. Under such circumstances, even containing, be that as it may, as the amount had already been, be that as it may, as the issue which was involved in the instant petition as to who should be making the payment has already been settled. Nothing further remains in the instant petition. Accordingly, the instant petition stands closed. Are you the petitioner? Are you the petitioner? Let me complete the order, then you say. The parties therein the parties in the state accordingly shall be at liberty to bring the execution proceedings to closure as per law and without being influenced by the observation. What is that? The proper head of the account. Later on, it should not be that we found out the head of. What is the matter about? What is the matter about? Non-payment. Not so. What is the what is the the civil court? So what? Why should we look into it? Prove it. They are disputing it. I'll reply. The counsel for the petitioner submits that he would like to file a reply to the affidavit in opposition filed by the respondents, taking into account the above. Is this matter again on? When do you want the dismissal? So early. 20. 20. Affidavit in reply be filed on or before 16th of March 2026. Item 10. Irrigation Department. Period.
Used for work orders of 14, 15, 15 and 17. Then where is the signature? Where is the signature? These are all 15. Running account bills, where is it showing? Why have you approached? When did you file this with petition? 2025, 10 years down the lane. Mr. You have difficulties? Uh, no. We direct on your statement, I direct the chief engineer irrigation to file an affidavit as regards the entitlement. The petitioner herein have claimed various amounts which the petitioner contends is due to him on account of various works awarded to the petitioner sometime in the year 2015 and 2017, 14, 15 and 17. Full stop. Notice was the instant with petition was filed in the year 2025. And notice was issued on 12/3/2025, thereby asking the respondents in the irrigation department to provide instructions to file an affidavit. In fact, by an order dated 19/11/2025, this court had granted time to the irrigation department to file the affidavit on or before 19/1/2026. But the said affidavit have not been filed. Today, when the matter is listed, it has been informed to this court by Mr. N. Upadhyay, standing counsel appearing on behalf of the irrigation department, that the concerned executive engineer has informed him that the amounts would be paid to him, paid to the petitioner, as per his entitlement. An instruction of such kind would not be in the interest of justice to be relied upon for issuing directions under Article 2 to 6 of the Constitution. Considering the statements made by Mr. N. Upadhyay, standing counsel of the irrigation department, this court directs the chief engineer, irrigation department, to file an affidavit as to whether the petitioner is entitled to the amount so claimed. It is observed that accordingly, this court fixes the instant writ petition on 27th of March 2026. Affidavit be filed on behalf of the Chief Engineer Irrigation Department on or before 23rd of March 2026. It is observed that if no affidavit is filed, it shall be construed that there is a delay caused by the Chief Engineer Irrigation Department, and this court would be constrained to pass appropriate directions.
11 and 12.
What is this? Training AI from doing the part of the language. Why are you not filing a civil suit? Then, what is the decree? Page? 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 Where is the decree?
Counted.
65. 65. The suit is decreed in contest. A decree for declaration that the plaintiff and against the declaring the plaintiff right, decree for permanent injunction against so and so firm against it's also passed in favor of the plaintiff and against the defendant, restraining the defendant from selling the land. Where is the decree for possession? No, where is the decree for possession? Where? No, where is the decree for possession? Mr. Day, you have to understand where is the decree for possession. That is why you cannot initiate execution proceedings. You are approaching this court under 226. Therefore, I am saying you cannot ask for an execution. Mr. Day, I understand what you are asking. You are asking that these persons 5, 6, and 7 are disturbing your possession, isn't it? And therefore direct them that they should not disturb your possession, isn't it? But where is the decree of possession and the permanent injunction not to disturb your possession? My question is that. Page 65. Yes. Not necessary. This is enough. No, I'm not going to look into the judgment. See the decree. What is the decree?
Yes, 64.
Right, title, and interest. Meaning thereby you are the owner. Okay. Number 2. What is the permanent injunction for? Not for restraining them from disturbing yours. File a suit. Mr. Chakraborty, am I not in your favor? Take your seat. No, I'm not looking anything. This is a civil dispute. You have a title. File a suit for permanent injunction. You cannot come here. No. No. And not necessary. If it was there and it was not granted, you know the consequences. No, you know the consequences. Section 11 will hit in. You are the owner. No, where is that? Where is the declaration to the effect? It has to be declared. No. Declaration. Then matter over. So dismiss or withdraw, which one? Either of it. Any of it. Either, both. I can give you both also. I can say that I am going to dismiss. At that stage, Mr. R. Day submits that he would like to withdraw and proceed to a competent court of civil jurisdiction. Either of it. Which one? Withdraw. You see a judgment of Justice J.N. Sharma, very beautifully given. In a way, in a suit, if you don't ask for restraining the possession, you cannot later on ask. In fact, you should have asked at that point of time. When you ask, now on the basis of which now you need to file a suit for only permanent injunction. 1998. Have a look at it. Withdraw. Mr. R. Day, heard Mr. R. Day, the learned counsel appearing on behalf of the petitioner, and Mr. B. Chakraborty appears on behalf of the respondent number 6 and 7. 7. Ms. U. Das appears for the respondent number 1, 2, 3, 4, 5. 5. First, the learned counsel appearing on behalf of the petitioner submits that taking into account that the dispute in question is a dispute which is a civil in nature, the petitioner would be well advised to approach the competent court of civil jurisdiction. And as such, the learned counsel submits that the petitioner would not like to pursue its remedies by way of the writ petition. Taking into account the above, the instant writ petition accordingly stands closed. Interim orders stands vacated. Contempt. What is the contempt? So your possession has been taken. The possession has not been taken. Wait. I know how to close this. Heard Mr. R. D, the learned counsel appearing on behalf of the petitioner. You are appearing? Notice has been issued? Don't appear. Oh, you have appeared. You have filed your Wakalat number. Mr. B. Chakraborty appears on behalf of the respondents. This is an application file alleging willful and deliberate violation to the order dated 10/7/2025, passed in WPC number 3858/2025. Full stop. From a perusal of the said order, dated 10/7/2025, it appears that the respondent number 6 and 7 in the writ petition were restrained from interfering with the peaceful possession of the writ petitioner over the land covered by DAG number 63, old /690, new of NK Patta number 15, old KP Patta number 116, new, without any authority of law. It is relevant to take note of that the question as to whether there is a violation to the said order cannot be looked in a proceedings of the present kind. More so, in addition to that, it is also the opinion of this court that the writ petition having now been withdrawn, nothing further, sir. Writ petition being WPC number 3858/2025 having withdrawn, nothing further survives in the instant proceedings. Accordingly, the contempt proceeding stands dropped. Yes, then go for correction of the decree. But did you pray for that? in the suit you paid. So you then say that is not the part you asked under 152. Yes, Mr. Dideka. Has been filed by some intention of is not entitled to any further amount in advance to have paid. You have filed your reply? Mr. Deka, have you filed your reply? Then you took time to file reply. Then disputed questions of facts. We should dismiss it. No, we gave you an opportunity earlier on 112. 3 months have gone. So they say that 71 lakhs have been paid to you. That is a question of fact. Trial court. No, not necessary. However, it is found that Mecca failed to submit the completion certificate from Iman, leading to deduction of rupees so and so. How much are you asking for? How much are you asking for? Huh? 30 lakhs 19,000. And what do they say? And that a payment of rupees was made towards Macron Iman. Further, Iman remaining installment of rupees so and so was paid towards here. Therefore, the total amount received by them is so and so. They have received all the dues and there remains no dues. Matter over. No, enough. Liberty. Mr. Tekar, no, sorry. Can't help it. I can't exercise here. I gave you an opportunity to file a reply. You didn't file it. No, they say that we have paid him 71 lakhs. So what was your total bill? Where? How many days did you put it? 19 days. Where? Page? Yes. Where? All the fixes fixed in rented area will have to be removed as soon as the model code of conduct is enforced by election. Okay, then. And what is the period for which you were given? Where is it? 20. Where? 20. It is for 1 month. So you did it for 19 days. Okay, so 19 days you did it. Now they paid you for how many? Now what do you want? So you want that as there was a condition in the contract that it was for 30 days, and the scope of the work categorically mentioned that it was for 30 days, but you did for 19 days, mode of conduct, so therefore you should be getting for 30 days. Fantastic. I think we should dismiss it. No, no liberty to civil court also. Liberty to civil court is too much. The fact remains that you only did it for 19 days. You are asking for damages. Mr. Decker, you are asking for damages. Understood, but you could only do for 19 days. You could not do for 11 days. You couldn't do for 11 days, which the contract otherwise permitted. Thereby, it was by which your contract was truncated and thereby reduced to 19 days. So the loss which you felt for 11 days is what you are asking, isn't it? So therefore, isn't it a case for damages under Section 73? Then what is this? I think liberty also can't be given to you. Madam, liberty? Should we? No, should we give the liberty? No, no. Eh? No. No, he's asking for this. Very difficult. Therefore, we dismiss it. Heard Mr. D. Decker, the learned counsel appearing on behalf of the petitioner. Ms. Udas appears on behalf of the respondent numbers 1, 2, 3. Full stop. The petitioner herein has filed the instant writ petition seeking a direction upon the respondents to release an amount of rupees 30 lakhs, 19,479 on account of work carried out as per work order dated 6/2/2021 and having admitted such dues on 8/12/2024 along with 15% interest per annum from the date of 8 falling due. The brief facts as would appear from the materials on record is that a short notice inviting e-tender dated 18/1/2021 was issued by the respondent number 2, thereby inviting advertising agencies having minimum 5 years experience in the field of outdoor advertising for designing, printing, and fixing of flags in permanent structures, rented hoardings for highlighting various development activities, achievements, schemes, message of the state government during the financial year 2020-21. A very perusal of the notice inviting tender reveals that the duration of work was for 1 month. Full stop. The petitioner, having the petitioner was selected as the bidder. First of all, it is relevant to take note of that though the period of the work to be completed, though the period for which the work was to be carried out was for a period of 1 month, but on account of, where is the document which says about model code of conduct? But on account of an AL, no? No, yeah. It is relevant to take note of that though in the notice inviting tender, it was mentioned that the duration of the work was for 1 month. But at the time when the work order was issued on 6/2/2021, it was categorically mentioned that all the flexes fixed in rented hoardings will have to be removed instantaneously as soon as the model code of conduct is enforced by the Election Commission of India. The resultant effect, also, the petitioner duly accepted the said work order. The resultant effect was that the model code of conduct was announced and the petitioner could only put up those hoardings / advertisement for a period of 19 days. The grievance of the petitioner herein is that the petitioner is entitled to a further amount for the remaining 11 days, as in the notice inviting tender, the duration of the contract was mentioned as 30 days. The materials on record further show that the petitioner had submitted bills to the tune of rupees 99,90,470. And the petitioner claims to have received 69,71,311. And the balance was rupees 30,19,159, for which the present writ petition was filed. It is relevant to take note of the affidavit in opposition which was filed by the respondent number 2, wherein it is mentioned that though the petitioner had submitted bill for rupees 99,90,470, however, it was found that the petitioner failed to submit the completion certificate from the office of the DIPRO, Dorong, and thereby leading to deduction of rupees 3,73,765. It was also mentioned that on the 19th day, owing to the coming into effect of the model code of conduct, the advertisements had to be pulled down. Accordingly, the total amount to which the petitioner was entitled to was rupees 71,53,174, which was duly paid to the petitioner. Full stop. The question therefore arises that in the proceedings under Article 2 to 6 of the Constitution, can this court direct payment of compensation on account of the petitioner having not been able to put up these hoardings, advertisements for the complete period of 30 days? It is relevant to take note of that the work order which was issued on 6/2/2021 categorically mentioned that the petitioner has to pull down the flexes, hoardings, advertisement as soon as the model code of conduct became operational. The petitioner accepted the said work order. Having accepted the same, the petitioner now, on the basis of the notice inviting tender, cannot claim for any amount beyond the period for which the petitioner had put up the advertising, hoardings, flexes. So accordingly, this court does not find any merit in the instant writ petition, for which the writ petition stands dismissed. No cost. Chalo, none appears. Mr. Sharma, why? There is no opposition against you in this matter. Earlier also, none has appeared for the petitioner. This is the second time that the petitioner is not represented. Mr. So and so appears on behalf of Mr. So appears for AFDC Fishery, and Ms. Yudas appears for the District Administration. Full stop. Taking into account that the petitioner have not appeared before this court on two occasions, it appears that the petitioner have lost interest in the present proceedings. It is also seen that the petitioner have also not taken steps as was directed by this court. Considering the above, the instant writ petition stands closed for non-prosecution. Where? How much is the amount? 16,55,000. So you have deducted the forest liability in respect of 3 contracts. That is the total amount. Ah. Okay. So you have done is outstanding forest royalty VAT on first. There's a VAT on forest royalty also. How can there be a VAT on forest royalty? You want to say there is a tax on forest royalty? Can there be a tax on tax? Forest royalty is one of the resources. So you may have the tax to ascertain another tax. Just for example, the income tax. When you are doing an agricultural income tax act, you are taking the agricultural income, you take 60% from the income derived and 40% is being done. So that can be done, understood. But how can there be a tax on forest royalty? Very difficult. Outstanding IT on forest royalty. IT means income tax on forest royalty. But the thing is, this court passed us very clear direction on 12/12. You have not filed the affidavit. After this court had fixed the matter after 2 months so that you within 1 month you release it to him. So you mean to say that we are to ascertain, we are to decide today on the basis of this report? No affidavit has been filed. So we'll take it on the basis of this report as to whether it. Huh? Let us see now. Yes, argue. We have given him a copy of this. Make a photocopy and give it to him so that he can argue. Oh, you argue? I've looked into it on this. Page 47. Page 47. What is there? Where? Huh? 40? Of the whole of the work, half the total amount retained is repaid to the contractor and half where the defect will be repaid. No. He is saying that we are doing it on the ground that they are entitled to some, they should have made certain deduction under the income tax. One. Now, if you have deducted the income tax, you must have deposited. That you will get it. There's no problem with that. So the moment you have deducted IT, you have to deposit it. VAT, you have deducted, it must have been shown. When did you deduct? No, because if you cannot deduct later on, because then there will be a penalty, huge penalty upon the irrigation department or whatever department it is. You have to deduct for that financial year. Then the third is forest royalty. Forest royalty. No. First of all, to deduct the forest royalty, did you give him a particular, well, when was this contract for? 2014, then section rule 5 of the rules of 2013 did not come in. 2003 was not there. So see, only in 2021, 5.3 of the rules of some minor mineral rules came in. 5.3. Prior to that, only rule 5 was there, which stipulated that you can give him a lease permit. You did not give him. Obviously. So you cannot deduct forest royalty on that. Secondly, forest royalty is payable under Rule 8, which says a forest royalty can be payable if he is holding a mining lease. He's not. So 8 does not come in. Then comes Section 27, Rule 27. If a permit is given for extraction of sand or clay, which is also not there. So his liability to pay forest royalty is not there. Only thing is what you can do. Only thing is you have to inquire. Have you made the inquiry that from there, those persons concerned, he has used this particular thing, the sand or whatever may be, the minor minerals which were being used, there is no payment of royalty. That is the issue. And tax too, you will get it, income tax. And VAT also you'll have a look at your site. Let me put it on the order. And if it is not so, we will impose interest on you, as I said in the earlier order. Pursuant to the order dated 12/12/2023, no affidavit has been filed by the PWD department. Be that as it may, a detailed report has been submitted by Mr. Be that as it may, Mr. B. Gogoi, standing counsel of the PWRD, have placed before this court an instruction dated 16/1/2026, issued by the Chief Engineer, PWD Roads. Perusal of the said instruction, to the said instructions, a detailed report have been enclosed. From a perusal of the said report, it is seen that on account of forest royalty, VAT, and income tax, various amounts have been deducted from the bills of the petitioner. They are as hereindunder: forest royalty, DES 9,50,655. Number 2, follow VAT 593,944. Number 3, income tax 109990. এখানে লাইন এলে দিয়ে দেবো, হলো দিব 1654589. The said instructions are kept on record and marked with the letter X. Taking into account that the respondents herein have deducted the said amount on account of forest royalty, income tax, and VAT, on which has components of, have deducted the said amount of rupees 16 lakhs so and so, which has components of VAT as well as income tax, the said aspect would be duly available in the petitioner's returns, duly available in the certificate so issued by the departments. For example, in the case of income tax, it would be the Form 26AS. For example, Mr. Petidas, the learned senior counsel, submits that he will ask his client, he will inquire to his assisting counsel about the said aspect. However, as regards the forest royalty, the learned senior counsel submitted that it is submitted that the petitioner herein is not liable to pay any royalty, taking into account royalty on minor minerals, taking into account Rule 8 of the Assam Minor Minerals from the Rules of Liability 2003 imposes the liability upon the mining leaseholder, and in terms with Rule 27, such the liability is upon the permit holder. Be that as it may, he shall inquire with his assisting counsel, to his assisting counsel, as to whether permits were issued to the petitioner in terms with Rule 5, on the basis of which the petitioner would be liable, on the basis of which the respondents, more particularly the executing agency, more particularly the PWD, would deduct as per Rule 5 of the Rules of 2013. A copy of the instruction, which is kept on record and marked with the letter X, have also been provided to Mr. So-and-so, who assists Mr. B.D. Das, the senior counsel. List this matter again on 25th of March 2026. A final liberty is given to the respondents PWD to bring on record their stand by filing the affidavits on or before 23/2026. You find out, Mr. Iya, as to whether income tax and because that it will be showing if there is any deduction. A copy of it, this is here. So how much it is being deducted is also being shown. Can you come up? Petitioner also given liberty to file additional affidavit if so desired. If so advanced. No, that certified copy. No, I'm not on that. I'm asking which certified copy you are saying. Forget about certified copy. What is the basis? Because that suit which he is mentioning. No, not the Sikha. Kuchini. You cannot mark just whatever may be. He says about a particular suit. Now, title suit number 202/2016 has to be pending in some court. He has brought on record a certified copy of title suit number 202/2016, wherein the dark number is different. My therefore purpose was on which title suit. Maybe there might be a suit in the lower division or even in the civil judge senior division. May also have different type of suits. There might be a title suit number 202/2016 in the Munsif Court, and one may be in the civil judge court. Because there it is differently registered. So therefore, he has to give us You merely because of a suit being pending, unless there is an injunction order, that cannot be a ground because the law is very clear. It shall be subject to the outcome. I think the section 52 of the Transfer of Property Act categorically says that. So therefore, you cannot delay this. Monday is today. No, because merely a suit being pending, they cannot be. Yeah. And I also say it shall not be a bar for the respondents to provide the no objections. Then what happened? Apply for the copy where? Whom? Chief Administrative Officer. Which one? Which court? In Munsif. In Munsif. He has got the Munsif one. That Munsif all are one. It is always Munsif number one mentioned because you never say Munsif number two. It is transferred. So this will be one only. So this is okay. So he has it out there in respect to Kamrup Metro. So there might be one out there in the civil judge senior division. That's all. There cannot be any other suits for the property. It is seen that pursuant to the order dated 16 to 2026, the Circle Officer, Dispute Revenue Circle, could not produce the certified copy of the title suit number 202/2016, wherein dark number 322 of KP Pata number 1014 of Revenue Village Jutikuchi under Moza Bentola of Dispute is pending. This court have also perused the records of the writ petition and more particularly the Annexure 8, which are certificates issued by the office of the various civil courts within the Kamrup Metro jurisdiction, within the jurisdiction of the district and session judge, Kamrup Metro. A perusal of those certificates clearly shows that there is no litigation pending till 21/10/2024, with effect from 23/10/2021 to 21/10/2024. In respect to the said land, Mr. S.S. Roy, appearing on behalf of the state respondents, district administration, seeks for a further time. List this matter again on 9th of March 2026 for further update. Huh? Mr. B. Chaudhary, the learned standing counsel of the APDCL, submits that he is yet to receive the instructions pursuant to the order dated 16/2/2026, and he submits that he would obtain the instruction positively without fail on 6/3/2026. Placed accordingly on 6/3/2026. Yes. Mr. Counsel, have filed a suit also? Then when? Haven't? After getting this order, did you disclose it in your petition? Then? No, why? Where? And how are you affected? Who? So who are you? Which were partners? To me? Huh? This is a different panchayat. Yes. Yes. And has this been extended beyond that? Yeah. But on experimental basis also, can you give it like this? The word used is different, na? Allowed to manage the new. Yeah. To deposit the following amounts to the underside, following detailed paragraph. Here also page 22 is the same. Understood. So this is 7,974 to be deposited for the entire period. Understood. He has got it after issuing an NP. My question is therefore, how are you having a separate, different thing with this? Means merely by using the word, are you not doing the same thing? Understood. That is why he is saying, look here, without an NIT, it has been given to somebody. How are you doing it? His quarrel is not only one thing. He says that first, they don't have the authority. Secondly, even if they have the authority, how can you give it to him and not call for NIT? Even on experimental basis.
My lord, if I'll go, my lord, the Assam Panchayat administrative rules, my lord. Rule 3 is the engagement of tax collector, my lord. Page 267. If we are little simple. Page 267, my lord. Rule 3, engagement of tax collector. As far as practicable, the post of tax collector as indicated under sub-rule 1 of rule 2 for each Zilla Parishad, Anshalik Parishad and Gaon Panchayat shall be filled up from out of the provincialized employees and so, provided that in case of non-availability of such employees, respective Panchayat may engage person in one of the two posts on commission basis at the rate of 30% on the tax collected by such engaged persons. Under no circumstances, the provision under subsection 1 of the section 140 of Assam Panchayat Act shall be applied in this.
So are you
But-
saying,
but-
are you saying
Yes,
that this Gaon Panchayat
my lord.
does not have a tax collector?
My lord, this is a on temporary basis exhibit, for example.
No. Are you saying that this Gaon Panchayat doesn't have a tax collector?
They have tax
Because
collectors.
if you see rule 1C,
My lord. Yes,
C,
yes, my lord.
2C, it requires to have a tax collector.
This one person is there.
So one person is there, so he can be very well the
My
tax.
lord-
If we are going on the basis of that, it's a tax collector.
My lord-
But it is not a tax
My lord,
collector.
practically what happens, my lord, there are numbers of ghats and bazaars are there. That is why, my lord, sometimes, my lord, under this provision, they engage some additional tax collectors. But in this case, directly, I'm not saying that as per this rule, he was engaged. But it is purely experimental basis, my lord. That is why for temporary, he was allowed to collect.
It's a different thing. If it is an experimental basis, nobody was interested. Then you could have appointed somebody.
My lord, my humble submission, in case of settlement, my lord, the additional amounts, the petitioner or any lessee, my lord, they can with them, my lord. But in this case, my lord, 100% he has to deposit in the department.
Where is it?
My lord, lordship may kindly see in the settlement of page number 22, it is already mentioned.
Let us see page 30.
Amount to be deposited.
Now page 30. Yes.
Yes, my lord.
Where does it say the entire amount is to be deposited? It only says similarly that you
Yes,
deposit
yes,
6020
yes,
for the
yes,
lease
yes.
period. So therefore, I would have understood that you issue a settlement process and the settlement doesn't work out. Then for that, you may have to appoint somebody from your side,
Yes,
which you can do under 105.
my lord.
You can do under 105, but you have not done that. But how can we allow these type of things?
In fact, my lord, second page I was not second page. I was thinking that only this page is there.
No.
Second, the amount to be deposited is also there. I was not my mistake at that part, my lord.
Who is appearing for the other side?
Colleague.
In fact, in this case, my lord, I have been engaged initially for temporary basis. Because on the basis of the demand of the public of that area, my lord, the guard is required.
We do one thing. We stay this. You continue with running this to your department.
That can be done.
That will do it department. But the fact that you have a right, because his Gram Panchayat is different from you. And if it falls within you, and the government has no problem with that, then do it. But the thing is, his and yours will be falling under the same Jila Parishad, na?
Yes.
Jila Parishad same.
Jila
Panchayat different.
Parishad will be the same.
Gram Panchayat
How
different.
much it is? Anchali?
Anchalik
Same.
also different.
Anchalik also required.
So Jila Parishad will be same.
Yes.
But if it is under the Jila Parishad and the Jila Parishad does not find any conflict between these two,
Right.
exercise of power by this Gram Panchayat with this Gram Panchayat, then this court has nothing to say. But you have to do this, you cannot do it by like this without a tender process. So we stay and you run it through under 105. Let him file his affidavit in the meantime.
After
Indeed.
fresh NIT, Lordship. After issuing fresh NIT,
Huh?
Department will issue fresh NIT, Lordship, in respect of the new Pagat, Lordship.
No, let them do it under 105.
Yes,
They have a power.
Government can run directly.
You see, the thing is, we cannot stop the Pargat from being operational. It is not that, you see, you have a right that if there was a tender issue, you could have participated. So therefore, I am stopping him. But you cannot have a right that they should not operate a Pargat. So let them operate it. Issue a settlement, they can do it. Or I can very well set aside. If you want, I can set.
Yes. It can be set aside. Otherwise, on 36,056, it will be infractions.
So we set aside this.
Set aside and.
You go for fresh tender. You go for fresh tender. In the meantime, you run it through department.
Lordship may suggest also, Lordship may observe that this order is set aside. Department can run 105, and if department wishes to issue NIT, they can create it as per.
That is what also I hope.
Yes, well, I understand it.
And Mr. A.T. Sarkar, the land counsel appearing on behalf of the petitioner, Mr. S. Dutta appears on behalf of the PNRD, and Mr. So-and-so appears for the
10.
response number 10. So-and-so appears for the district administration. For the response number 2. 3. Others he appears. The petitioner herein is aggrieved. The petitioner herein, who is the settlement holder, of two ghats, namely Sor to Silovatus, why is 21 of the name of the ghat, and so, under the Asani Sor Gaon Panchayat, Bagula Mari is agreed by the settlement made in favor of the respondent number 10 by the respondent number 8 on 2 grounds. First, that the Bir Singh Gaon Panchayat did not have the authority and jurisdiction to grant the settlement in respect to the ghat from Aminechar to LNT Road, Aminechar. The second ground so taken is the said settlement so made in favor of the respondent number 10 is without following any tender process, which is the mandate of section 105 of the Assam Panchayat Act 1994, or short, the Act of 1994. This court has passed an order dated 10/12/2025 inquiring upon the respondents, more particularly the PNRD department, as to whether the Bir Singh Gaon Panchayat had the authority to establish a new Parghat, and whether the same has been done by following the mandate of the Act of 1994. Today, Mr. S. Doctor, appearing on behalf of the respondents, submitted, placed before this court an instruction dated 13/2/2026, which is kept on record and marked with the letter X. From a perusal of the said instructions, it seemed that the very instructions, it is mentioned that the petitioner herein have been agitating his grievances before two forums. One, before the learned court of the civil judge, Junior Division, Dhubri, in title suit number 235/2025, wherein an injunction application was filed being Ms. J case number 340/2025, and the same being pending, the petitioner could not have filed the present writ petition, seeking the similar reliefs. The second aspect which is mentioned in the said instructions is that the Bir Singh Gaon Panchayat has the authority in as much as the Parghat from Amenachar to L&T Road, Amenachar under Bir Singh Gaon Panchayat is within the Bir Singh Gaon Panchayat jurisdictional area. It is also mentioned that on account of the construction of the Dhubri-Phulbari bridge, it has become one channel of Dhubri side and another channel in Phulbari side has been left open because both the channels are main streams of river Brahmaputra, which are used for crossing ships, launches, and engine boats, etc. It was also mentioned that people of the South Salmara district as well as the nearby area of Meghalaya state use the L&T road for their easy communication between Dhubri to Phulbari by motorcycle, and they have to cross the main channel of river Brahmaputra by engine boat. And the channel of Dhubri side, due to change of course of the river Brahmaputra presently passing through the village Amenachar, which has fallen under the jurisdiction of the Bir Singh Gaon Panchayat. It is under such circumstances, on experimental basis, this Parghat, that is from Amenachar to L&T Road, was set up on an experimental basis. Further to that, it is also mentioned that the petitioner herein has no right to say anything pertaining to the affairs of the Bir Singh Gaon Panchayat as well as the Bir Singh Zorua Anchalik Panchayat. And the area of the newly created Parghat, that is Amenachar to LNT Road, has not fallen within the territorial jurisdiction of the petitioner's leased area. This court have also heard Mr. S. Dotto, the learned standing counsel of the PNRD, on the issue, on the question as to how the respondent number 10 was granted a settlement without following the mandate of section 105(1) of the Act of 1994.
106.
106, no?
Earlier also 106.
Earlier also 106.
105 is
106. The learned counsel had submitted that this was done on an experimental basis. And as such, no tender was floated. It further submitted. I don't put that, no? This could have given an anxious consideration to the respective submissions as well as also perused the materials on record. At paragraph number 8 of the petition, the petitioner had duly stated that the petitioner had filed a suit and as well as an injunction application which were pending before the learned court of the civil judge, Junior Division at Dhubri. Mr. A.T. Sarkar, the learned counsel, further submitted that in the meantime, on 7/2/2026, 17/2/2026, the said suit had been withdrawn. This court have also taken note of that the jurisdiction this court have also taken note of that the Bir Singh Gaon Panchayat has the jurisdiction in respect to the area falling within Amenachar to LNT Road, Amenachar. And the petitioner herein who is a lessee in respect to two ghats, as already stated, under the Bhasanichar Gaon Panchayat, cannot question the jurisdiction of the Bir Singh Gaon Panchayat unless there is a dispute amongst the two Gaon Panchayats. Nothing has been brought to that effect before this court. Under such circumstances, it is therefore the opinion of this court that the Bir Singh Gaon Panchayat has the jurisdiction to set up a Perghat from Aminachar to L&T Road at Aminachar. This opinion would, however, this opinion, however, is given on the basis of the materials before the court. And without taking into account the stand of the Dhubri Jila Parishad, under whose jurisdiction both these Gaon Panchayats are situated. Be it as it may, it is pertinent to take note of that though on experimental basis, the Parghat from Aminachar to L&T Road is being run, but settlement of the said Ghat has to be in terms with section 106(1) of the Act of 1994. This court have duly taken note of Annexion 9 to the petition, whereby the respondent number 10 have been granted the settlement of the said Parghat for the period from 30/11/2025 to 30/6/2026 without following the mandate of section 1061 of the Act of 1994. Under such circumstances, it is the opinion of this court that the Annexion 9, that the settlement dated 27/11/2025, by which the respondent number 8 have granted the settlement to the respondent number 10, the Parghat, the Ghat from Aminachar to L&T Road, Aminachar, cannot be sustained in law. Accordingly, the instant writ petition therefore stands disposed of with the following observations and directions. The impugned order dated 27/11/2025, by which the respondent number 8 have granted settlement to the respondent number 10, the Parghat, namely from Aminachar to L&T Road at Aminachar, is bad in law and accordingly set aside and quashed. Number 2. The respondent number 7, 8, and 9 shall be at liberty to take recourse to settlement of the said Ghat by following the mandate of section 1061 of the Act of 1994. Number 3. Till such period, till such time, the respondent number 7, 8, and 9 shall run the said Parghat with direct management departmentally by shall run the Parghat
Or as per
by the respondent number 7 and 8 and 9.
1065.
Department. 7, 8, and 9 department.
In this case, petitioners have not submitted the required testimonials before the authority lordship, such as death certificate of his father, next of kin certificate,
Huh?
bank detail lordship.
Petitioner has to submit the
The required documents such as bank details, indemnity bond, next of kin certificate lordship.
Because the original petitioner has died. So his next of kin are before is on record. Money has already been sanctioned and lying with the district commission. Petitioners advocate that approach the district commissioner's office several times. Each and every occasion, this council was requested by the office of the district commissioner kindly submit the testimony along with indemnity bond and all other things, madam. For us to disburse the money, because money cannot be disbursed to any other person, when somebody comes and cannot be done. So there is a procedure that if we cooperates to that extent, it will be released.
you must be recording in some order or verbally.
I believe,
Verbally, no. Verbally, the things doesn't work, na?
no, it's like with them. So once he goes.
So when he is approaching, he must be writing a letter to them.
10 to 2026, I
He
approached my.
has been asked, kindly.
No, my lord, no.
All verbally. How can I verbally happen, Mr. Board?
No, my lord, he will, then he will have to make an application, formal application.
He has made a formal application.
Made application, my lord.
Yeah.
This is my application, my lord.
But then he has not given all the testimonials, as has been requested by
You have to ask him.
Never asked, my lord.
Why is it verbally said?
the.
When an application is made, don't you create a file? Are you not enjoying 45,000 per month as interest?
Already there, lying.
It is not lying out there. It's not a, yeah. You like it? They're lying out there for years. It's already a 1991. We are 25 years,
So then,
35 years.
then my lord will direct the authorities, my lord, to, my lord release the money on satisfaction of, my lord, the credentials of the.
No, you are to therefore put it on record somehow.
Final academy.
File your affidavit by the district DC on 5th. 5th, file your affidavit. Why it has not been given, in spite of the order being passed. You have produced that order,
Yes, my lord.
then also not passed. Why? Let the DC file an affidavit.
Your petitioner already substituted by this honorable court, my lord. The earlier petitioner Ranjit Kolita already been substituted by this honorable court by legal half, my lord.
But you have to submit the legal certificate.
No, he has not.
Next of kin.
This honorable court already been substituted, my
No, it is how
my.
Maybe please.
Do you think that I am the collector?
Presently, I don't have for my.
I am not the collector.
No.
Collector is that. So therefore, you have to submit your next of kin certificate. The substitution here is different from there. Don't you think?
My.
You do one thing. You submit the next of kin certificate.
Presently, he has no next of kin, my lord. To be applied.
Huh?
He has not applied.
Not applied, my next of kin.
Apply.
My.
Apply and get it.
Right.
Because have you obtained a succession of that particular person?
Well, only that land is mutated in favor of based upon the Gauhati certificate, my lord. Land has been mutated in favor of both the present petitioner.
Your name.
My lord.
Gauhati certificate will not do now. Next of kin has to be given. Apply for the certificate.
My lord.
The authorities are requesting for the death certificate, income death certificate, my lord, the bank details of this person to whom, my lord, the money will be transferred.
Ordinarily, these should have been written by letter, not by verbally.
And we'll have to take instruction whether is at all may not this what they have done, because this is so appears to have been submitted on 10th of February.
So therefore, it was the bounden duty of them.
Yes.
So we will instruct them for it. We will instruct them right now, ma'am. But then my corollary obligation is also on this part. We'll have to also, my lord, they had a next of kin, my lord, delegated to the suits of the my lord original petitioner. They will also have to, my lord, submit the indemnity bond. Formalities, my lord, when the money is finally at the end of the day disbursed by the authorities. This is what I am.
If you issue the notice that you have received the money, kindly come and collect it. My question is this, there you mention it, no? The indemnity bond, give me this, give us this. Have you done it?
We will instruct the
You have not done it. So then, why will their responsibility be? You have to tender it to him. This court had passed an order on 6/2/2026, thereby directing the respondent number 4 to disburse the decretal amount to the petitioner, the awarded amount to the petitioner, taking into account that the central government had already deposited the said amount with the respondent number 4. Mr. So-and-so, appearing on behalf of the petitioner, submitted that on 10/2/2026, when an application was filed, the respondent number 4, the office of the respondent number 4, however, have not given any regard to the order passed by this court on 6/2/2026. Today, when the matter is being taken up, it has been informed that the petitioner is required to submit the next of kin certificate, the indemnity bond, the bank details, etc., which the petitioner have not submitted. This court inquired with the learned counsel who submitted. This court inquired with Mr. N. Gusami, the learned counsel who represents the district administration, respondent number 4, as to whether there is any order passed in that regard or any file maintained. Surprisingly, it is submitted that the same has been done orally. It is no longer res intriga that when an amount is being deposited before the collector, it is the duty of the collector to intimate the person concerned who is the beneficiary for the purpose of collecting the said, for the purpose of submitting the necessary documents so that the amount could be disbursed. It cannot be. This court can't give a blind eye to the fact that the petitioner have already been deprived of his land as far back in the year 1991. 501.
Iraq amendment.
91.
Yes, ma'am.
91.
91. And 3 decades have already passed in the meantime, awaiting compensation to be paid for the land having been taken. Taking into account the above, this court directs the respondent number 4 to issue communication to the petitioner forthwith and not later than 3 days from today. And not later than 5 days from today. The notice intimating that the amount have been deposited and what the petitioner is required to do. Let's list this matter again for an update on 10th of March 2026. Mr. N. Goswami, the learned counsel, appearing on behalf of the respondent number 4, shall forthwith, without fail, intimate the respondent number 4 about the order passed.
Publish.
Yeah, please a motion. Last occasion, this honorable court was faced to ask for instructions from the respondent side.
What happened?
My lord, some
Why no sanction?
some discrepancy, my lord, with regard to the report submitted by the state debt audit board. Submit কৰিলওঁ মই তাৰপিছত দিম। Yes.
Yes, DC. Why are you not acting?
That's mine. Let me take stuff on that. It was 10 on 9, 12, 2025.
Now, next problem will be that person may not be there.
My lord.
Now, the new income is already been going. Simply go.
No. Now the question will be that person who made that state debt audit report may not be there. This is another thing by which you are going to delay it. Now tell me, kindly come to this election 9, page 24.
Yes.
This is on 4/2/2025.
Yes, my lord.
Insofar as the petitioner hearing is concerned,
Yeah.
kindly see here. Certificate from DC State Debt Audit Board's report.
Yes,
These are the two you are asking for.
yes, my lord.
Then this is being given by the DC to the Joint Secretary, submission of the proposal for sanction.
Yes,
As per the so-and-so, ex gratia has been approved for so-and-so 50 lakhs in compliance to that serial number and necessary verification has been carried out. The proposal was forwarded along with the so-and-so, including the state regard, departmental recommendation, departmental engagement and NOK. The above is so-and-so, so-and-so. This is the certificate. So along with that, they have provided the state debt audit reports.
yes. But it does not bear the signature of the chairman
How is it possible?
because we have to be doubly sure.
Does
my lord.
this disease, they don't know that it requires the surgery.
Then our project to that our these documents already been sent. Like it was signed.
And it was given on 9/12.
No, Lordship, it was given on 8/9.
Then 9/12 they gave it. And after that, this has happened.
That is that's on I don't know. Because only because of 10 we have to calculate this level. What was
We have it there after 2 weeks. You produce the state state debt audit report which was placed by the DC in pursuance to the communication dated 8/9/2025. Because you must be having a copy of it.
I will. That
The DC will have a copy of it.
might be, madam. It's already.
Whatever document you are sending, you'll have a copy of it. Not produce it. And the document which is with you, you also produce. The present petition has been filed by the petitioner, being aggrieved by the delay of almost 5 years, of more than 5 years in granting the benefit of the scheme whereby the state government promised an amount of rupees 50 lakh to those COVID victims who died in the line of duty. The materials on record, as well as the verifications so carried out by the district administration, clearly shows that the petitioner, who is the wife of late Lufta Rahman, is entitled to the said amount. It is very pertinent to take note of that on 4/2/2025, the Joint Secretary to the Government of Assam, Revenue and Disaster Management Department had written letters to various deputy commissioners, including the DC, the district, various district commissioners, including the district commissioner Dhubri, seeking certain documents. Insofar as the case of the petitioner is concerned, two documents were sought for. One was the certificate from the DC, and the second is the State Debt Audit Board's report. Seven months thereafter, the District Commissioner Dhubri submitted the proposal for sanction of the ex gratia in favor of the petitioner. Along with the certificate of the DC. And it is also seen that it includes the State Debt Audit Board reports. This aspect is apparent from Annexure 10 to the writ petition. The petitioner being aggrieved by the delay in the sanction being granted by the Revenue Department have approached this court by filing a writ petition. This court issued notice on 9/2/2026 inquiring with the Revenue Department as to why the sanction had not been granted. Today, Mr. R. Bopazari, appearing on behalf of the Revenue and Disaster Management Department, had placed before this court an instruction issued by the Joint Secretary to the Government of Assam Revenue and Disaster Management Department, dated 2/3/2026, wherein it is mentioned that the state debt audit report so submitted by the district commissioner did not contain the signature of the chairman of the State Debt Audit Board. And in that regard, a letter was issued to the District Commissioner Dhubri on 9/12/2025, but there has been no correspondence by the District Commissioner Dubri in that regard. A copy of the communication, copy of the instructions of place is kept on record and marked with the letter X. This court is perplexed by the communication which is kept on record and marked with the letter X, read with Annexure 10 to the writ petition. Roman 10. Inasmuch as this court fails to understand why the district commissioner, Dubri, at the first place, had sent, after 7 months, a state debt audit board's report without the signature of the chairman of the state debt audit board. Further to that, why, even after 2 months thereafter, 3 months thereafter, the DC administration, the district commissioner, Dubri, have not acted on the communication dated 9/12/2025, issued by the Joint Secretary to the Government of Assam Revenue and Disaster Management Department. List this matter again on 30/3/2026. The respondent number respondent number 2 as well as the respondent number 5 are both direct. The respondent number 4 as well as the respondent number 5 are both directed to bring on record their stand by filing the affidavits. In the said affidavit, the respondent number 4 we filed by the respondent number 4, the state debt audit board's report qua the petitioner husband, so submitted by the respondent number 5, be placed on record. The respondent number 5 shall also bring on affidavit as to explaining the delay in submitting the due report and
I need some more. Need some more. 1 week time lordship only.
why?
But that I already been communicated, but I have not received the instruction. And the verbal instruction, that
I gave you 1 month. 1 month isn't
No,
it the
no,
period?
only that
No,
they,
is it
they
1
already
month
been,
the period of giving 21A?
no, already they have been rejected their pilot that NOC lordship.
They rejected it.
Rejected. Why it is been rejected? That instruction I am waiting.
Okay, next week, file your affidavit.
Friday lordship.
This Friday.
Next Friday.
No, next Friday is too long. This Friday. Saturday?
It's pilot that
This Saturday. We'll have it this.
can it be on Monday?
No. Because of these things. Because of the thing that it is 1 month you have to give the NOC. Or you have to inform that you are rejecting.
Whether it has been informed or not, that instruction I have.
Does it take 1 month to get it? Because I issued notice on 9/2. But did you think that this court would not be sitting again in this bench? Okay. Mr. J. Hendrick, the learned counsel appearing on behalf of the respondent numbers 2 and 3, submits that he has no instructions pursuant to the notice issued by this court on 9/2/2026. It appears, therefore, the Respondent number 2 and 3 have not taken the benefit of the services offered by Mr. J. Hendick, the learned government advocate. Under such circumstances, list this matter on 9/3/2026, on which date the respondent number 3 shall be personally present through the video conferencing link provided to be provided by Mr. J. Hendick, explaining as to why the NOC, which is required to be granted within a period of 30 days in terms with Section 21A oblique 2000 of the Registration Act 1908 have not been issued. Mr. J. Hendick shall provide the video link so that the respondent number 3 can be present at 10:30 a.m. before this court. What is this?
My lord, regarding my lord, police harassment, my lord, it is not obtained, my lord, bail, my lord, and thereafter, my lords, appeared before the IO, and the IO, my lord, on the day of appearance, my lord,
Person alive, dead,
my lord.
person is alive.
Yes, my lord.
Who are these people? All of them beaten up.
No, my lord. Petition number 2 and 3 were beaten up, my lord.
Why the others are filing the case?
Others, well, my lord, filing, my lord, because, my lord, their statement has not been recorded by the IO, my lord. Despite, my lord, they appeared, my lord.
Huh?
Despite they appeared before the IO, my lord, after getting anticipatory bail, my lord, their statement has not been recorded, my lord. And they were also, my lord, threatened that they will also harass, my lord, like the petition number 2, 3, my lord.
Affidavit filed by respondent number 3.
Yes, sir.
What about 5 and 6? Who is appearing? Service complete. Service complete.
Service complete, my lord.
Are these people still working in the in charge?
My lord, that respect I don't know.
Yes, Mr. Roy.
Lord, you have to take instruction.
Inform these people, because if they don't file, this is a case of constitutional thought. If they don't file, then they are made named by person. And why no affidavit has been filed by respondent number 4?
Lordship, affidavit filed by,
Respondent number 3 is different. What about 4?
there was a, Lordship, inquiry was there, Lordship. The inquiry report has been filed after receiving the complaint, Lordship. Page 69, the inquiry report. There was this allegation, Lordship. We have made an inquiry, Lordship. The inquiry report is there, Lordship. Page 69.
Where are the medical reports?
Lordship, it was not annexed, Lordship.
Yes, my lord. I have annexed, my lord. Medical report also annexed, my lord.
No, the
But
medical
they, on
reports.
the inquiry, my lord, yes, my lord. In terms of inquiry, my lord, medical reports, the inquiry was done, my lord. And my lord, categorically, my lord, in the affidavit to notice filed by the respondent 3, my lord, they also, my lord, categorically accept, my lord, admit, my lord. They also admitted, my lord, in the affidavit to notice filed by the
Not
respondent number 3,
admitted,
my
Lordship.
lord.
There is a hot altercation was there, but no torture was there, Lordship.
No torture was there, my lord, but the
was-
IC Borsala PS, my lord, scolded that part is available in the affidavit, my lord. My lord, kindly see page 64 of their affidavit, my lord. Rather, when they were about to leave IC Bosala OP. That is my lord, respondent number 6.
It is seen that the respondent number 5 and 6 have been arrayed as by name. And service have been meted out, but they have not filed their affidavit in opposition. Mr. S.S. Roy, who appears on behalf of the respondent numbers 1 to 4, shall intimate this court as to whether the respondent number 5 and 6 shall file the affidavit or not in this matter. This court further fixes this matter on 6th of April 2026. On the said date, the official respondents shall produce the records of the inquiry report, which formed the basis of the inquiry report, enclosed as Annexure 1 to the affidavit in opposition filed with respondent number 3.
Novelist.
Lordship, I'm appearing on behalf of Mr. P. Mohantar, Lordship, for the petitioners. He had a medical emergency, had to leave urgently, Your Lordship.
You are appearing in which case?
Lordship, Gauhati Gymkhana, item 31. Lordship, also there is a connected matter, item 33, connected with this item. Lordship.
Madam, this is a case which cannot be, other review is okay. But this
This is, it will not lie, Lordship.
requisition should be dismissed.
Lordship, my senior will address the court better, Your Lordship. If he was there, he would address the court better, Your Lordship.
Earlier, Mr. M.K. Chaudhary was appearing. He is also in the hospital.
No, no.
Then, where is it? Huh? Anyways, we don't care about senior counsels. We don't require their presence. Whoever it is. You are arguing? You
Lordship.
dismiss your case.
Lordship. My senior will address the court on the next date, Your Lordship.
Mr. P. Mohantar was appearing here
Yes.
and his father has filed that application there. Could
Yes.
it there be a conflicting
There will be
interest?
conflict of interest.
Again,
Your Lordship, he'll be engaging Mr. B.D. Decca, Your Lordship. He'll be engaging Mr. B.D. Decca, Your Lordship.
where?
In the
No,
Brahmakumar
not
Mohanta
there.
matter, Your Lordship.
But here he is.
Not there.
Here he is appearing.
Mr. P. Mohantar is appearing here,
Here, yes.
and the review petition is filed
both
by
are
the father.
connected.
Again, the conflict of interest won't arise.
Yes, Lordship.
And because of that, if the conflict of interest arise, why should we grant an adjournment on behalf of a counsel where there is a conflict of interest? You should dismiss it at your hands. Let's dismiss it.
No, Lordship. Take the matter on another date, Your Lordship. He'll address the court.
Why so many pleadings?
Lordship.
Why so many pleadings in this petition?
We just filed an affidavit, that's it.
No, affidavit filed by respondent number 2, affidavit
Yes,
additional
one by
affidavit,
the-
respondent number
by the
1, rejoinder by
Register of
petitioner.
Firms.
One by the register of firms,
Register of
and we
Firms.
filed a reply. We filed an opposition.
We filed an opposition
That's it.
and they filed a response to that.
Due to paucity of time, the matter could not be taken up. And as such, list this matter again on when?
13th, Lordship.
13th March 2026.
Correct.
Wait, please, can I make a mention of it about item number 23? Can it come on fifth, Lordship?
Why?
Because we have some urgency, this is a contempt.
Otherwise, Lordship, order has been complied with.
Right,
Yes.
No,
10:20.
Copy the bullet.
23.
No,
Oh,
Lordship.
that order,
Yes, yes, Lordship.
Let it come on fifth, Lordship.
the settlement,
Yes,
which I do, some order I passed, no?
yes, yes.
It
Lordship.
doesn't mean comply, order passed.
No, no, not compliant.
No. I've directed them to pass the order.
No, no, Lordship. In view of above fact, these authorities have considered view that the matter involves substantial issue of law which cannot be finally adjudicated within the limited jurisdiction of. Accordingly, the parties are at liberty to approach the competent civil court.
Yes.
They have, Lordship, this was the end. What the revenue board said was them to for the settlement. Now they are not settling, nothing they are doing. They have again asked us to approach because what
Yes.
the hearing was done by Mr. Hemonga Nobis, Lordship, and this order, I think, is passed by.
You have to challenge this order, madam. See, first of all, section 100, this civil court is referred under section 100. When there is a dispute between two parties, then it will be referred to the civil court.
There was no dispute. Nobody appeared. They have said, Lordship, that notices were sent. Notices, Lordship, here, Srimati Jairam Rajbangshi, Jairam Rajbangshi already dead. Torun Das already dead. Then they write the parties appeared, were represented, were heard.
Then you have to challenge this order, madam.
Before the civil court or before Lordship itself?
This, you have to challenge it before me, before
Then
court number 5. We
10,
close,
10,
we
Lordship.
close the contempt petition accordingly.
No, Lordship, let me.
No, absolutely no. Contempt has to be closed. Order has been passed.
Court number 10, Lordship. I'll approach court number 10.
No, court number 5, he's taking bench 5 matters.
Or bench. It will bench.
There's no court. This is whoever takes bench
Uh-huh.
5. I am taking bench 4, 5. Therefore, the present contempt application was filed alleging willful disobedience and non-compliance to the directions passed by this court by the order passed by this court dated 9/11/2023 in WPC number 6395/2010. So, sir, today, Mr. S.R. Bolwai, appearing on behalf of the respondents, have placed before this court an order dated 26/2/2026, whereby in compliance to the said order dated 9/11/2023, passed in WPC number 6395/2010, the said proceedings have been disposed of, thereby relegating the parties to the civil court. So the said order is kept on record and marked with the letter X. In view of the said order, the instant contempt proceedings stands dropped. Be that as it may, the dropping of the instant contempt proceedings shall not prejudice the petitioner to assail the order dated 26/2/2026, if so advised.
Yes, Lordship. Highly obliged.
Obliged.
I make to mention item number 9. 29. Item number 29.
What is that?
My lord, that is review petition. That is registered on 10th, my lord.
Why?
Because they are.
Review for what?
Of your lordship's order.
What have I done wrong? What have I done wrong? What have I done wrong?
My lord, I was at the time of argument, this one. My lord, on 2 grounds, my lord.
What ground?
First ground, that one later. What I say? Inspection report dated 23/1/2023, my.
No ground.
That,
I think appeal. Not a ground of review.
that is there, my lord, even though it has to be disposed of on various matters.
I dispose of it right now. They'll let me
Now,
dismiss it
that-
right away. 2 minutes. No grounds of appeal review made out. Finished. Heard Mr. O.P. Bhatti, the learned counsel appearing on behalf
My
of
lord,
the
let
review
it come
petitioner.
on Monday and
No
on
grounds
Monday
for
your lordship
review
say.
petition made
Right.
out, and according the petition says dismissed.
This
3 grounds.
letter may come on Monday, my lord, and it can, in that case.
No. This will come after
Dismiss.
6 months. Okay, list this matter again on 30th of November, March 2026.
Item number 2.
That's all.
What is that?
Compensation granted by this honorable court lordship.
Okay, no,
That-
others,
Lordship, nine,
others
nine
এইখিনি
limited.
চাই লো প্লে কি আছে চহী কৰিবলৈ late for orders কি
So it-
Take the dates and all. If there is any contempt complied with, inform that we will close it.
Lordship, from our part, we have done all this,
It's
but
okay,
it's pending
then
before the
we'll go
finance.
back. We'll have a look at it and pass the order.